except for Miss Acevedo's client.
Yep.
Where is she? Do you know where she is, Miss Acevedo?
Uh, Judge, I don't believe that she has been served, and I haven't had personal contact with her.
Okay. Miss Kyler Green, do we know anything about service?
Service was attempted, Your Honor, and it was unsuccessful.
And Your Honor, I actually spoke with the mother and her mother, and she plans on going to New Mexico and going into treatment. But that's that's the only information that I received. They didn't provide an address or anything else. The grandparents have one of her other children, and they're willing to, take in Layla so mom can go to treatment in New Mexico.
Okay.
Your Honor, our position today, and we can get this on the record, but our position today is that we'd like to have another reset to allow more time just to ensure that this is actually what is happening, and just to see if we can find more information.
I think it's fair. It's not too much trouble just to put it on the docket again, and if she doesn't do what she's supposed to do, then we can look at other things. When is she supposed to go? I know this is all off the record, but when is she supposed to go to Mexico, Miss Ford? Do you know?
From my understanding was as soon as possible. She is I don't know where her sister lives, but allegedly she's with her sister right now. She is not with the Aaron, her boyfriend, who was controlling her. I even spoke to Aaron's sister, who said that she is gone, that she left when Aaron was sleeping. And so I just couldn't get any address from them. I encouraged her and her mother to speak with Miss Acevedo, and they didn't. And so I don't know what to tell you. I mean, that's the plan, they say. They did send pictures of Layla to me. Again, I can't confirm anything because I've never seen her before. I don't know if they're old pictures or, or not.
Okay. Miss Greenlee, do we have a 9 a.m. setting on the 20th or the 9th?
We already have a 9 a.m.
Okay, what's the next Medina date after that?
The 16th.
Let's do it then. Do we have availability?
Let me take a look at that because there's an asterisk. There's a trial set that day, and I'm not sure. Set it for 9 a.m. on the 16th.
Let's do that. And if the department between now and the 16th of April changes their plans, Ms. Kyler Green, if you just communicate that to the attorneys, and then maybe we can do something in anticipation of that hearing date. But if we need to have the hearing, we'll have the hearing.
Yes, sir. Thank you.
All right. Thank you all for your time and your service. All parties are excused. I'll just circulate a reset order, please. We don't need to put anything on the record. We don't have her here anyways. Everybody else will show up from the courthouse in Kendall County. All parties are excused. Thank you.
Thank you.
No objection.
No objection.
No objection.
With that, Mr. McKeska, would you please begin the announcements?
Thank you, Judge Drake McKeska, attorney for the department.
Shelley Nix, belong permanency specialist.
Lindsay Ligon, belong permanency supervisor.
Irene Acosta, attorney ad litem, appointed to represent the mother, Brianna Sansom.
Charles Weatherby, attorney for the father, who's in custody of TDC, and not ready but not opposed to proceeding.
Kendra Sims, attorney ad litem for the children.
Amy Harding, Hill Country Casa supervisor, guardian ad litem for the children.
Brenda Eberso, Hill Country Casa, guardian ad litem for the children.
Ms. Sansom, did you announce?
No, sir. Brianna Sansom, mother to the kids.
We're here today for a permanency review before final order. And I'll go ahead and just start with what I know. Ms. Nix, there's no Indian child heritage in this case, correct?
Correct, Your Honor.
Permanency goal is still family reunification with Ms. Sansom?
Yes, it is.
All right, and the children are still in their relative placements at this time?
Yes.
That placement is safe and appropriate, meeting their needs?
Yes, it is.
Is it in their best interest to remain in that placement?
Yes.
And this is the least restricted placement available to the children?
It is.
I understand they're up to date on all their checkups?
Yes, sir.
And there may be some developmental delays, correct?
Yes, sir.
Are they being appropriately addressed?
Well, they're in the process. I'll keep it brief. Because of the move to San Antonio and then back to Fredericksburg, the transition from the agency in San Antonio to the agency in the Hill Country, we had delays due to the placement's lack of response to those services. So I've since reached out to Hill Country ECI. They've indicated that due to the lapse, they would prefer to rescreen because things can change over a couple of months since they last received services. And because we have expanded Ms. Sansom's visitation, the plan is for her to be available to participate in those in-home services. So the screening is currently due to be scheduled and we'll proceed from there.
All right. Do you believe that, I mean, from what I read, it doesn't seem like as if they're suffering. There just may be some concern. So you believe there's anything else that needs to be done or ordered in that regard today?
No, we just need a definitive answer from ECI about Atticus's speech in particular. He is, what, 21 months old, and he's really not talking or babbling. And so I do believe he's in need of speech, but he's still young, and it's certainly something that intervention will help.
Okay. And the visitation with the mother, those visits are appropriate?
Yes, they are.
Are you asking for any changes to the current visitation schedule?
No, the court has always been very lenient as far as visitation and agreement amongst the parties. And I think that CASA, Ms. Harding in particular, and Ms. Sims and I have all worked together appropriately to devise a very specific visitation plan that suits the children's needs and Ms. Sampson's needs at this time. And so I think that we as a group will continue to broaden and expand her visitation as appropriate.
Okay, good. Glad to hear that. And then obviously Mr. Menchaca is not having any visitation. He's still incarcerated.
Yes, sir. He's been incarcerated since October in a facility down in San Diego, Texas. He's due to be released next month, about mid-April. He's participating in one of those drug treatment,
Right.
correctional programs.
And at this time, we'll just stay on the father before I go to Ms. Sansom. At this time, is he in compliance with the services that he's being offered at Safety?
Yes.
All right. You believe that he's complying as much as he possibly can?
Yes, I do.
Okay. And is Ms. Sansom in compliance?
Well, she's positively in compliance. I'm so pleased with her progress. She was released from her mandatory program in mid-February, returned to Kerrville, immediately got a job. She's seeing her counselor. She's in contact with her probation. She's taken drug tests, which she's passed. Parenting, she's doing exceptionally well. And she's visiting her children a lot.
That's what I read, so I'm glad to hear that everything is still the same. It's great news. And do you believe that it's in the best interest of the children to remain in the temporary managing conservatorship of department / belong at this time?
Yes, it is, Your Honor.
And do you believe that it's safe to return the children to either parent today?
Not yet, but we're getting there, Your Honor.
Okay, so it's your testimony that the parents still have to demonstrate some more compliance before you'll feel comfortable returning the children.
Yes, sir.
Okay. And I think that's all I have at this time. Do you believe that the parties would benefit from mediation? That's the other question I had.
Yes, sir. We do need a mediation.
Okay. Mr. McCaskill?
No questions.
Ms. Acosta?
Yes, Your Honor, thank you. Ms. Nix, what is the plan moving forward with regard to the mother?
It is family reunification with Ms. Sampson, and for her to continue her very liberal visitation schedule. And that certainly will be expanded as appropriate, but our plan is to reunite the children with her.
Okay, and are those visits currently unsupervised?
Well, not by the department, but all we're requiring is that Ms. Harris, the primary caregiver, the maternal great-grandmother, be in the home, but she doesn't have to be under direct supervision, with the expectation that she's taking primary responsibility for parenting her children and seeing to their needs while she's there.
Okay, and how long will she continue to be needing supervision for while she's visiting the children?
Miss Harding and Miss Sims and I have not discussed, her being able to have unsupervised visitation, like say outside the home, but that is certainly something that we will continue to address as far as I explained earlier, broadening her visitation.
Okay, given her substantial compliance with her service plan and the fact that her visits have been going so well and she's engaged in everything, do you think that it would be appropriate to start unsupervised visits?
I think that's something we can probably best address at mediation, but I can certainly reach out to Miss Harding and Miss Sims to talk about that prior to that. Although she's making exceptional progress, she has only been out about a month, and I would like to see her continue to participate in her current services and stay in compliance before we move to unsupervised.
Okay. Are there any safety concerns with mom at this moment?
No.
And she's appropriate with the children, correct?
Yes, she is.
Okay, I'll pass the witness, Judge.
Mr. Weatherby,
No questions, Your Honor.
Ms. Sims.
I don't have much to add, Your Honor. Miss Sampson is doing wonderful. I got to supervise part of a visitation or be there during part of the visitation. She was very appropriate with the kids. I think our biggest thing now is just these kids are so small and she hasn't been with them for a big part of their life, and it's just the bonding. And I think this liberal visitation of her visiting, several times a week will help with that. So other than that, everything's going very well.
Ms. Ebersol.
I've also attended part of a visit, and Ms. Sampson is doing very well. Like Ms. Sims said, the kids need to bond with her because they haven't been with her much, but this is really helping. I've noticed a difference since I saw her the first time, and then the last time they're doing much better.
Good. Thank you. Anything further from anyone else?
Your Honor, I would just like to address the court.
Please.
Your Honor, given Ms. Sampson's substantial compliance with her service plan and the testimony that she's, visits have been going really well, she's doing exceptionally well, I would like to request that her visits transition into unsupervised visits with her children. I know that Belong has testified that that's something that they're moving toward and they'll talk about it, but I would like it ordered so that it can begin sooner rather than later. I understand that mediation is requested and that it could potentially be discussed at mediation, but I don't think that at this point it's necessary if mom is being appropriate with the children. I think that it is something that could be done sooner rather than later so that she continues to progress.
Thank you, Ms. Aposa. Any response to that?
Judge, I just asked the court authorize the parties to move to it. I think that the things have been working well in this case regarding, the parties working towards the unsupervised, and I don't think there's any reason to upset the apple cart at this point.
Anybody else?
Your Honor, I don't think we're quite at unsupervised yet. As Ms. Nick said, Ms. Harding, myself, and her have been working together and have been very liberal in trying to expand Ms. Sampson's visitation, but this has only been happening for a few weeks, and I would like to see it continue before we move towards unsupervised.
Thank you. I'll address that here in just a moment. Let me rule on everything else. For the purposes of the permanency review before final order, court finds there's no Indian child heritage in this suit. The permanency goal of family reunification with Ms. Sampson is appropriate in the best interest of the children. Court finds that their placement with Ms. Harris is safe and appropriate, meeting their needs and in their best interest to continue. Court finds this is the least restrictive placement available. It's family. Court finds that both children are up to date on their medical checkups, and I'm going to order that we get that rescreening set up as soon as possible so we can get those delays addressed. I want to see advocates get the speech therapy and anything else that they might need. So let's put that in order. Court finds that mom is in compliance with her family plan of service. Mr. Menchaca is in minimal compliance with his plan of service. Court finds that he is adhering to everything that he can do in safety and that he's working towards completing his goals. Court court finds that it's not safe to return the children to either parent today, and that as of today, neither parent has fully addressed all of the concerns. However, and I want to take a time out here and give Ms. Sansom a round of applause for completing inpatient and remaining engaged in her aftercare. That is a huge accomplishment. I'm very proud of you and the progress that you've made. You're welcome. I do believe when it comes to the visitation, I want to make a finding that mom completed aftercare or inpatient and is engaged in aftercare at this time. And I encourage you to continue that and stay on top of it. I think there's a lot to be said for, and Ms. Nix pointed it out, Mr. McKeska pointed it out, and Ms. Sims pointed it out. Parties are doing really well with what's happening, and there's the old cliche, if it's not broke, don't fix it. So I think that there's a lot to be said for how things are going. I think everybody has a good bead on the tempo of this case. So what I'm willing to do is look at a May 1st hard begin an unsupervised visits date if it hasn't begun already. So if we're looking at a dismissal date of July 22nd, we've got a trial date May 23rd. I think I'm looking at, in my opinion, based on what I'm hearing and what I've heard throughout this case since December, I think a May 1st deadline is more than appropriate. Hopefully things have started unsupervised before then, but I would not want to see it after that. So I'm going to order that the parties remain authorized to handle visitation as they see fit, but that we at least need to begin some sort of unsupervised by May 1st, if not before. I'm going to find that both parents are still indigent. Mr. Menchaca is still incarcerated, and Ms. Sansom is just in the fledgling stages of recovery and working. So the last thing I want to do is put the burden on her of having to go pay for an attorney. So I'm going to find they're both still indigent. I'm going to order the parties to mediation prior to our trial date, which is May 23rd, 2024 at 9:30. May 23rd, 2024 at 9:30. And I would encourage you to try to mediate as close to that trial date as possible, because I would like to see another 2 months of progress before we come back to trial. Is there anything I failed to address?
No, Josh.
I just need to admonish the parents. The state of Texas gives parents in CPS cases 12 months to demonstrate you can provide a safe, stable, violence, and drug-free home for your child. In the event you cannot do so, your rights are subject to restriction and or termination. Again, good work, Ms. Sansom. Thank you all for your time and your service. I'll see you May 23rd at 9:30. All parties are excused.
Thank you, sir.
With that, Ms. Kyler Green, would you please begin the announcements?
Good morning, Emily Kyler Green, attorney for the department.
Carol Maketa, family-based supervisor.
Maria Salinas, caseworker, FBSS.
Anna Swallow, attorney ad litem for the respondent mother, Maren Owings. Miss Owings, are you able to unmute and state your name?
Yes, ma'am. My name is Maren Owings. I'm Uncle's mother.
Kathleen Savage, attorney ad litem for the child, Your Honor. I'm ready.
All right. We are here for a progress hearing today. Who's going to be giving the testimony?
Ms. Salinas, Your Honor.
Okay. Ms. Salinas, we were here on March the 8th for a compliance hearing. I think Ms. Maketa might have testified that day that there was some issues. Things were not going as well as the department had hoped. And there was an FGC ordered and then this progress hearing. As of today, Ms. Salinas, what is the situation? I can see that Ms. Owings is incarcerated, so obviously that's clear, but what else do you want to report today as far as the progress?
Yes, Judge. Marin is still non-compliant. She did do a drug and alcohol assessment where she was ordered to go to inpatient. That was actually delayed because she told the assessor that she did not want to go to inpatient because she didn't want to lose her daughter, even though Donnie.
Can you all hear me?
I couldn't hear you.
Okay, I'm objecting to hearsay. She's talking about what her provider told her that my client said.
All right, Ms. Salinas, let's not say anything that anybody else gave you information on, like the provider. If Ms. Salinas, or excuse me, Ms. Owings told you, that's fine. But if it's somebody else telling you what Ms. Owings said, that's hearsay. Okay.
Yes, Judge. Maren was ordered to go to inpatient. She has not. And at our FG, y'all had ordered a hair follicle. She did test positive for methamphetamines and marijuana.
Judge, to hearsay again, she's giving the results of the hair test.
Well, Your Honor, for purposes of what the court has asked is to this, what this hearing is for, the progress and how mom is continuing and whether or not she's successful in her TFF case. The results of the hair strand test are not being brought in for the truth of the matter, but to determine the next steps that the department is taking.
I disagree, Judge. There's another way that question can be asked besides going straight to what the results were of a hair test. I understand if I'm overruled, but I will object to hearsay.
Well, just considering the nature of this hearing, I'll sustain the objection. Ms. Kyler Green, let's get there another way.
Do you want me to take over the testimony?
Yes, please.
Okay. Ms. Salinas, you said that as a result of the FGC, Ms. Owings did comply and receive a hair follicle test. Is that correct?
No, that was from the court order on March 8th.
Okay. Was she also asked to do a UA?
Yes.
Okay. Did she complete a UA?
No.
Okay, but she completed the hair follicle test. Were the results of that concerning to you?
Yes.
Okay. And were there any actions that you took as a result of the results of the hair test?
No, we already had done the parent-child safety plan.
Okay. You began your testimony by saying that Ms. Owings was not in compliance. What else did she not do?
She was ordered to do outpatient when she didn't comply with the inpatient, and she went to one group and then did not return and did not attend any of the other groups.
Do you know why?
No.
What else was she supposed to do?
She was supposed to go to therapy, and she went and did an intake, and then she didn't make it to the next one because she was arrested.
Were those therapy sessions in person or virtual?
In person.
And was that as a request of Ms. Owings?
It was from the original orders from the TFF.
Okay. Did Ms. Owings ever express to you a difficulty with transportation and attending the therapy visits?
No, we offered.
Did you inquire as to why she was unable to attend more than one, or was it just because she was arrested?
It was because she was arrested. Her next appointment was 2/26.
What date was she arrested?
2/21.
Were there also concerns throughout the duration of this case that Ms. Owings was having communication with the alleged father?
I'm sorry, can you repeat that?
Were there also concerns throughout the duration of this case that Ms. Owings was having communications with the father?
Yes.
And why was that concerning to you?
Because he has admitted to me that he uses heroin and meth.
That he is a current user of heroin and meth?
Yes.
Okay. Did you have concerns throughout the last few months that Ms. Owings was continuing to use?
Yes.
And what was that based on? Not from what someone else told you, but why did you have those concerns?
Because she repeatedly lied to me when I would go and visit her. And I had a positive drug test.
Okay, without talking about the results of the drug test, what do you mean that she lied to you? And can you be more specific about that?
Do you want me to go through the lies that she's told me?
Why don't you start with just naming an example of a lie that she told you?
So on January 30th, I visited her, and she told us that I had asked about Opal and had she gone to see the doctor, and she told me yes. That she had seen the doctor and had her 3-month appointment. She had not. Opal has not seen the doctor since she was 3 days old, has no immunizations.
Okay. And why is that concerning as to Ms. Owings' ability to care for her child?
Yes.
Why?
Because Opal wasn't getting what she needed. Her checkups, her regular checkups at the doctor's office.
What other services was Ms. Owings supposed to complete?
Other than therapy and drug treatment?
Yes, but she's supposed to be attending a parents as teachers program?
Yes, she was.
Okay, and did she complete that program or attend that program?
Yes.
Was she successfully discharged from that?
Not yet.
What is still needed in that program?
You would have to talk to them about how many more sessions. I don't know how many more sessions she needed.
Is she able to continue with that program while she's incarcerated?
No.
Okay. Do you feel that the continuation of this case is conducive to Opal's best interest?
No.
And why not?
Because currently she can't care for Opal, and Opal's placed in a parent-child safety plan with paternal grandparents.
How long has she been in that PCSP?
Since March 5th.
Okay. And what about Matthew?
Matthew has had no contact with me.
And have you attempted?
Yes, several times. One time he asked me to meet him at 7 o'clock in the morning in Comfort, and I went there and he never showed up.
Okay. Has Matthew attempted to make contact with Opal?
No.
Has Matthew ever made attempts to visit the shelter where Opal and Miss Owings were residing?
Yes, at the shelter, yes.
Okay. Your Honor, I have nothing further. Thank you.
Ms. Swallow.
Thank you. Miss Salinas, your testimony was that my client was arrested on 2/21. Did you mean 3/21?
I'm sorry, yes, 3/21.
Okay. And did you attend the family group conference on the 19th of this month?
Yes.
Is there a reason why you did not mention your concerns regarding Opal's healthcare at that family group conference?
Because we had not confirmed that.
Okay. Is there a reason why no one from the department has ever mentioned to me your concerns regarding potential concerns regarding Opal's healthcare?
Because we took Marin's word that she had seen the doctor.
Okay. And how were you able to confirm that Opal had never been to the doctor?
Because she went to the doctor yesterday and we were told that.
Okay. So you don't know for a fact that Opal has not been to the doctor, do you?
She has not been.
Ma'am, it's a yes or no question.
Yes.
Okay. Let me ask you, Miss Salinas, since the last hearing and at the family group conference, were you aware that my client has seen Miss Joni Chavez Martel, her therapist? She had seen her twice?
No.
Okay, she saw her on this March 7th and she saw her on March 12th, correct?
No.
Okay, we discussed that at the family group. If that's disputed, why didn't you say anything at the family group?
Because I just talked to Joni and she said,
okay, I'm objecting to hearsay.
I had not confirmed.
She's asking a question, and
I think you can handle that on cross, Ms. Carla Green.
And
excuse me.
Thank you, Judge. Were you aware that she had another appointment set for the 26th of March?
Yes.
Okay, but she was incarcerated, so she can't go, can she?
Okay. Yes.
And she met with Donnie with Hillcotta for her outpatient on March 14th.
Yes.
And inpatient was recommended.
Yes.
And it was discussed at the family group that my client was actively trying to get into inpatient, correct?
Yes.
And we discussed different facilities, did we not?
Yes.
We discussed Serenity House and Journey.
Yes.
We even paused the family group so we can make some phone calls to these facilities, did we not?
Yes.
Okay. Are you aware of whether or not my client participated in the intake for an inpatient program?
Yes.
Okay. And are you aware of the fact that she was just waiting on a bed?
Yes.
Specifically with Serenity House?
Yes.
Okay. And in regards to the PAC program, have you received any information that she was not compliant with that program?
No.
And we also discussed domestic violence would take place with the Gillespie Battered Women's Shelter, correct?
Yes.
So as far as services go, it sounds like she became very actively engaged, correct?
No. I would not agree.
Okay. We just went through every service. Am I missing one?
No.
Okay. In regards to Opal, is she in any sort of danger right now?
She is not, because she's with
Okay.
parent.
Thank you. And also, Miss Salinas, Opal was placed in this safety plan prior to becoming incarcerated, correct?
Sure. Yes.
I know that the department was also discussing looking at other relatives for Opal to live with during this time period. Did that occur?
No.
Do you know why?
Because the grandparents agreed to take her.
Okay. Did we not have a conversation yesterday?
I'm not understanding your question. Yeah.
Miss Salinas, did we have a conversation yesterday? Yes or no?
Yes.
Okay. We had more than one, did we not?
Yes.
And in the initial conversation yesterday morning, we discussed a paternal uncle, did we not?
Oh, yes, yes.
Okay. And I'm asking if the conversation was, if the department had a conversation with that family member.
I have not had a conversation with that family member.
Do you know if anyone at the department has?
I believe that Carol was going to try, my supervisor.
Okay. So at this point, what are you recommending to the court?
I'm recommending that we end the TFF and have a dismissal.
Okay, and then what? You know, I'm
And
going to object to
then
this line of questioning. This is not something that this witness can necessarily answer at this time.
Then she can say, I don't know.
Well, I think we're asking her to make almost a legal conclusion.
Okay.
To go further than that.
Fair enough. Miss Salinas, if the court does not dismiss the case for which you're asking, or even if the court does dismiss the case, what is your position, the department's position, on Opal having visitation with my client?
She could have visitation. We had arranged that.
Okay, so you're not opposed to these grandparents taking Opal to the Gillespie County facility to see her mother?
I couldn't object to that.
I'm sorry, you could not, or you could?
No, I wouldn't.
You would not object to that?
No.
Okay. Do you know the charge for which my client was picked up, was that an old charge?
I believe it was from last August.
Okay. And do you know how long my client will be incarcerated?
No.
Thank you. I pass the witness.
Ms. Savage.
When you say the drug charge was from August of 2023, correct?
Yes.
And Opal was born October 8th of 2023?
Yes.
And that was a felony drug charge for methamphetamine, is that correct?
Yes.
And mom has a long history of meth use, is that correct?
Yes.
She actually lost her older child to her parents because of her drug addiction, correct?
Yes.
Speculation.
Have you talked to Marin about her child custody arrangement with her
I just
older
made an
son?
objection.
I know. I'm trying to.
I'll rephrase, Your Honor.
I'll sustain the speculation objection.
Ms. Salinas, have you talked to Ms. Owings about her custody arrangement with her older son?
Yes.
And what is the information she gave you as to that child?
Relevance, Judge. Objection, relevance.
Your Honor, this goes to her compliance in these services, the need for a dismissal of this case. And this is exactly what this case is for, this hearing is for.
You can answer that question.
I'm sorry. Kathleen, what was the question?
What information did Marin give you about the custody arrangement involving her older child?
From my understanding, this is what she told me. They gave custody, awarded custody to her parents, and the only way she can get him back is if she cuts Matt out of her life and she produces one negative hair follicle.
And to date, she still doesn't have her older son in her custody, is that correct?
Correct.
Okay. Were you also in attendance at the first FGC we had on February 28th, I believe?
Yes.
And in that meeting, the mother testified how she wanted nothing to do with Matthew, or didn't testify, but stated she wanted nothing to do with Matthew.
Correct. Yes.
And she herself had concerns because of his drug use.
Yes.
She stated she lost her car and the child's birth certificate because of some of his antics?
Yes.
Okay, and so she was adamant she had cut this man out of her life, correct?
Yes.
A week later, did she show up with this man to a visitation?
I was not present.
Okay.
But yes, that's
So
what I was.
Judge, then hearsay, if she wasn't present, then I don't know how she knows what she's answering to.
Well, you can take her on board diary, Ms. Savage, find out how she knows it.
Ms. Salinas, how were you informed that Miss Marin and Matthew were at that visit together?
I was told that by the person who supervised and Carol. I'm not sure if my supervisor was present, but I was told that.
All right. Ms. Laquetta, were you present there?
No, Judge, I was not.
All right, then let's just move on from that.
Miss Salinas, have you asked Miss Owings if she's had any contact with Matthew in the last, 30 days?
I haven't not asked her specifically.
Okay. But do you have concerns that she has been in contact with him?
Yes.
I'll pass witness, Your Honor.
Redirect.
Yes, Your Honor, briefly. Ms. Salinas, did Ms. Owings ever tell you that she was going to accept a ride from Matthew for a visitation?
No.
Do you speak to Ms. Chavez about whether or not Ms. Owings had attended any of her therapy appointments?
Yeah, she had missed one and attended one.
Okay. Was there concerns about continuing therapy if Ms. Owings had not completed an inpatient treatment?
Yes.
Okay. And at this point in time, at this point in time, how long has this case been going on?
Since December 11th.
And has Ms. Owings attended any inpatient treatment since December all the way until March 28th?
No.
And has that been recommended to her?
Yes.
Do you feel like the Department of Belong has done everything it can to help facilitate all services for Ms. Owings?
Yes.
Has Ms. Owings minimized her problems with drug use throughout the course of this case?
Speculation.
It's a direct question. She either has knowledge that Ms. Owings has minimized to her, Your Honor. Sorry, that was implied in the question.
What was the objection?
Speculation, whether or not someone's minimizing or not.
And you're stating, Ms. Carla Green, that you're asking if she has said those words to her, or
I asked to her knowledge, has she minimized her drug, or I think I said throughout the course of this case, has Ms. Owings minimized her problem with drug use? It's an opinion based on the caseworker who's been working with her, Your Honor.
I see how it could be speculative, but I think in this context, it's okay. Overruled.
Ms. Lena, thank you. Nothing further, Your Honor.
Any other recross, Ms. Swallow?
No, Judge, I just need to address the court.
Anybody else have any other witnesses?
Your Honor, can I ask a follow-up of Ms. Salinas?
You may.
Ms. Salinas, you've reviewed the intake for why this MTP began. Is that correct?
Yes.
Okay, and this intake began because the mother tested positive for meth and opioids at delivery.
Yes.
Okay, so this has been an ongoing issue. We're almost 4 months into this MTP and drugs is still a concern for the department.
Yes.
I'll pass witness.
All right, let me hear argument from Ms. Carla Green.
Your Honor, did you want to say something else? I'm sorry.
Yeah, go ahead.
Okay, I apologize. The department's position at this time, Your Honor, we are over 4 months into this case and have not been able to see any progress with Ms. Owings. It has been almost a wild goose chase in getting her to complete services and getting her to be honest with the department about where she is, who she's with, what she's doing, all to the detriment of this child. For the time being, Your Honor, the child is placed in a PCSP that does not last very long. And the department believes that at this point, court-ordered services are not effective enough to protect this child and to and don't believe that Ms. Owings has a strong desire to actually continue with these services and get them done for the benefit of her child. So we're requesting a dismissal. Thank you.
Ms. Swallow.
Thank you, Judge. Following the last hearing, I believe it was a huge wake-up call for my client. She hit the ground running. She did become compliant, in my opinion. She reached out to all of her providers. She continued to stay active with the PAT program. She was serious about going to inpatient. She was setting up her appointments with Joni Chavez Martel, with Hilcata. She was taking everything very seriously, I think, but not for the fact that she was picked up on this old charge. She would be an inpatient right now. I honestly believe that, and that's my representation to the court. So this is her current situation is due to, past choices that she has made. But I will say the court's orders were that he needed to see a rapid turnaround. I will let you know that while it's unfortunate she is currently incarcerated, following that hearing, she did take your orders very seriously, and she did engage the way this court expected her to. It's unfortunate that she was picked up on that charge. I believe that the child is safe. My client is willing to sign a power of attorney to these family members to take care of Opal. She has no desire to do anything to threaten Opal in that place. I would request that the court keep this case alive. I do not believe my client is going to be incarcerated for very long. This is her first offense of this nature. And that's my request to the court. Thank you.
When is her pretrial date?
Her pretrial date is April 11th. And her trial date, I think it's May 6th.
Ms. Savage argument?
Your Honor, this should have been a legal case from the get-go. We had a baby and a mother test positive for methamphetamine at delivery. Mom had from October 9th to the TFF case was even filed to address her drug issue. She hadn't. Kind of sort of started right in December when this case started. Here we are in March getting positive drug tests. We're getting reports that she's still associating with a heavily involved individual in drug addiction and drug use. At the FGC a month ago, she was adamant. I have no desire to be around this man, no connection to him. I want nothing to do with him. He brings my life down. And then within a week, we're getting reports that they're showing up together for visits. There's not one thing that anyone can believe that comes out of Miss Owings' mouth. And the person who is suffering by all this is Opal. She's in a family, a safety plan right now. However, they're not willing to keep her long term. These are grandparents who had no intention of being parents to a small child again. Opal is an infant. Mom can do inpatient drug treatment in a legal case, but it's not in the best interest of the child to keep dragging this out when mom has a very long history of drug use and not just marijuana. I mean, we're talking about methamphetamine. This is a serious drug addiction. So no, I don't think we're going to be successful at an MTP. She's had 4 months. We're not seeing any changes. It's actually getting worse. This child, it needs to be a legal removal, in my opinion.
Ms. Scarlett Green, rebuttal.
I don't have anything to add.
For the purposes of the progress hearing, I want to make some findings. Court finds at this time Ms. Owings is non-compliant. Court finds that the results of the hair follicle test the court ordered her to take were concerning to the department. Court finds that Ms. Owings did not follow the recommendations of the drug and alcohol assessment, and that she was arrested before she was able to complete a therapy session on March the 21st, 2024. Court finds there's evidence that she was also in communication with the alleged father, who admitted to Miss Salinas that he is a user of heroin and methamphetamine. Back on the 8th, there was the orders that I made, and I did want Miss Owings to turn things around. And if she tried, then I appreciate that. But the problem is that this is a TFF case, and she's incarcerated, and she's going to be incarcerated at least until mid-April, if probably not longer, if this is a felony drug charge. So I don't see the efficiency or even the legal possibility of making a TFF case work. So that, in addition to, as Ms. Savage correctly described it, a very serious drug problem, it's just too much. It's too much for me to give this another another ring on the bell. So I'm going to dismiss the TFF case. Find that it's in the best interest of the child to dismiss the TFF case because of the lack of progress pursuant to statute. And there'll be no further hearings in this matter. I think I have addressed everything. I wish we weren't here. That's all I'm going to say is that I wish we weren't here, but we are. Thank you all for your time and your service. If nothing further, all parties are excused. I'll see some of you after. Well, Ms. Vanderbilt, I guess this is where we find out the answer to our question from our conversation on Tuesday. We have an adversary where we've got no parent. So is there anything that you all need to discuss before we begin? Is there anything that you want me to do before I call the case?
Your Honor, I haven't talked with the child attorney yet. If we could have a minute.
Absolutely.
Thank you.
And I see we've got Linda here with us. Hi, Linda. In the 454th Judicial District Court of Medina County. The court is streaming from Kendall County in the courthouse via Zoom and YouTube. Is there any objection?
No objection.
No objection.
Ms. Kyler Green, would you please begin the announcements?
Yes, good afternoon. Emily Kyler Green, attorney for the department.
Alexandra Vanderbilt, supervisor for the department.
Christy Knapp, permanency supervisor with Belong Observing.
Kathleen Savage, the attorney and guardian ad litem for the child. Your Honor, I'm ready.
Linda, is it possible for you to unmute and state your name as well?
Linda.
All right, thank you. Ms. Vanderbilt, and I guess, I don't know, Ms. Knapp, you're not going to offer any testimony today, are you? Okay. Then just Ms. Vanderbilt and Linda, would you both please raise your right hand?
Yes.
All right, thank
Yes,
you.
Your
And Linda, this proceeding is for your benefit, so there's no reason to be nervous. We're here trying to help you, okay? So just relax. All right, Ms. Kyler Green, how do you wish to proceed?
Thank you, Your Honor. So I think the agreement forward is we filed a removal in this case. It's my understanding that the individuals who had custody or the parents of Linda are deceased. We don't have, or the parent of Linda is deceased, and we don't have a certified death certificate for that yet. And so we filed a removal. We're going to ask today that removal be granted, that Linda can remain in the facility where she is at. And so we're asking for temporary managing conservatorship up until the point where we can obtain a certified death certificate. There are no other parents who have custody or individuals, adults who have custody of Linda, and the only one who did have legal custody is deceased. I'll let Ms. Savage handle she still is in contact, Linda is still in contact with some family members, and I'll let Ms. Savage handle the amount or the recommendation as to continued contact. It's also my understanding that the child is in agreement with this plan.
Okay, Ms. Savage.
One last thing, Your Honor.
Go ahead.
I would like to get some testimony from Ms. Vanderbilt as to the efforts that the department made with the family who was caring for Linda prior to our filing a removal.
Okay. Then first, let me ask Ms. Savage. Ms. Savage, is this your agreement?
Yes, Your Honor, it is.
You've had a chance to discuss it with Linda?
Yes, and actually, if I'm correct, she goes by Zay. Is that right, Linda? Yes, Zay.
Zay.
So I met her yesterday. She wants to stay where she's at. She is asking for contact with a couple of relatives, Mr. and Mrs. Henderson, who were the aunt and uncle she was staying with at the time this case started, and then her sister Donna and her aunt Sandy. I don't believe there's any objection to Donna and Sandy, but I do believe department has some concerns for Mr. and Mrs. Henderson.
We do, Your Honor, and we would just ask for any continued contact between them to hold off until it's been therapeutically recommended, and Zay has an opportunity to meet with a therapist who can assess that situation and ensure that it's in her best interest to have that continued contact.
All right, then Ms. Kyler Green, why don't you put on your evidence?
Thank you. Ms. Vanderbilt, will you be testifying?
Yes.
Thank you. What's your role in this case?
I am the supervisor for the department.
And when did this case first come across come to the department? Sorry.
February 28th, 2024.
And were you did it come as an investigation?
Correct.
And what was the allegation?
The allegation is that Zay had been left at the hospital with nobody to pick her up.
What kind of hospital?
It was a mental health facility.
Okay. How long had she been there?
Since February 26th was when she was ready for discharge. And the 28th is when we had gotten the intake.
Do you know what was her initial day at the hospital?
I don't recall.
Okay. Were investigations able to make contact with the family who she had been staying with up until that point?
Yes.
Okay. And was there inquiries made as to why they had not come to pick her up?
Yes.
Okay. Do you recall, based on your review of the file, what the reasons were that they could not pick her up?
Due to the ongoing mental health concerns.
Okay. Did the department make efforts to assist the family with services or resources that would help them be able to pick her up regardless of the mental health concerns?
Yes, both in this case and one that had closed recently.
Okay. Can you provide some examples of services that were provided to the family or offered to the family?
We connected the Hendersons with grandparents raising grandchildren in order to help them get legal custody of her, in order to get the mental health services. The biggest barrier they had is that they could not take her for outpatient services because they could not consent. They also had issues with transportation. The department offered to provide them transportation even after the investigation closed, to get her engaged in some outpatient services with Hill Country MHDD.
Okay. In regards to the transportation, did they utilize that assistance?
No, they did not.
Okay. In regards to the inability to consent to treatment, was that as a result of them not having custody?
Correct.
And so were services offered to assist with them in having some sort of custody to enable them to be a medical consenter?
Yes, multiple times.
And did they refuse that?
Correct.
Any reason why?
They just continued citing the mental health.
Okay. And so at this time, have you had an opportunity to speak with Zay about what it will mean for her to be under the temporary managing conservatorship of the department?
Myself, I have not.
Do you have an understanding as to whether or not someone has from the department?
Yes.
Okay. And do you know what Zay's desires are for her future?
Long-term residential treatment.
And it's my understanding that education was an issue prior to her coming into care. Is that correct?
Correct.
What was that issue?
She had been homeschooled and she wanted to go to school and be like other teenagers.
Okay. And has she been able to do that since she has been at the treatment facility?
She has not, but only because she has been hospitalized again.
Okay. Is that in the works?
Yes, that's the goal.
Okay. Are there any steps that need to be taken by Belong in order to achieve her education, since that is one of her primary goals?
Not that I'm aware of.
And in regards to the therapeutic recommendation for contact with the aunt and uncle, are there any other concerns that you have besides just potential triggers for Zay with her aunt and uncle that you'd like to inform the court?
Mr. Henderson is also a registered sex offender.
And when did you discover this?
Today, actually.
Okay. Is that something that you would like an opportunity to look into as well in regards, in addition to the therapeutic recommendation?
Yes.
Okay. Your Honor, I have nothing further. Oh, actually, I'm sorry. Do you think it's in Zay's best interest for the department to be granted TMC?
I do.
Okay. Thank you.
Savage.
No questions, Your Honor.
Any other witnesses?
No, Your Honor. Thank you.
I think the testimony that I just heard is sufficient for reasonable efforts as well, unless there's something else. Ms. Savage, you're satisfied?
Yes, Your Honor, I am.
Okay, I think I am too then. Anything else you want to add, Ms. Savage?
So it's Zane and it's him, he, I apologize, just for clarification. But when I went out and met with Zane, he wants to stay there. He likes it at Touchstone and believes being in foster care is in his best interest.
Okay. Miss Kyla Green, besides the TMC order and the contact and the therapist request, are there any other orders that you're asking the court to make today?
No, Your Honor, not this time.
All right, Zane, you're here. Is there anything that you want to add?
I really want to talk to my aunt and uncle.
Okay. I understand that. I've heard that through the testimony and your attorney's representation to the court. Do you feel like you understand what's going on here today?
So far, I guess not really.
All right, well, I'm gonna, as the judge, I can't give you any legal advice. So I'm gonna just give you a basic overview of what we're doing. And then if you have more questions, you can certainly talk to your attorney about that, okay? Her job as your attorney ad litem is to represent your best interests, and guardian ad litem, and to make sure I understand what you want, and then to answer your questions that you have, okay? What we're doing today is I'm going to make some findings on the record. And then the department is asking me to grant the Department of Family and Protective Services for the state of Texas temporary managing conservatorship over you, which means they will be your temporary parent or guardian. And we will have hearings throughout this case where they will bring information to the court. Your attorney will have the opportunity to bring information to the court. And in those hearings, I will oversee your care to make sure that you're getting the services and the help that you need, to make sure that you get to go to school, and to also make orders for contact with the people who've been named here today, and then any other orders that are necessary to provide for your best interests, okay? It might be confusing sometimes, but I want you to know that my job is to protect you and to ensure that the things that I just said are done. So if it's confusing or it doesn't make sense, just remember that all the decisions that are made have to ultimately come through me. And that's going to be based on all the information that's provided to me, which includes what you tell me. And you have the opportunity through this case to attend every hearing because you're over 12. And you have the opportunity to speak to me privately if you want to. Okay? So if that's something that you want to do in the future, you tell your attorney and she'll get with my court coordinator, Ms. Greenlee, and we'll get a meeting set up where you can come to my office and talk to me with your attorney, or we can do a Zoom call, kind of like this. Okay? Does that all make sense? I know it might be confusing right now, but okay. All right, then. Court finds, for the purposes of this adversary hearing, that there is, at this time, no legal managing conservator, parent, guardian of the child. And the court finds that the mother, Betty Carter, is deceased, that there's no father before the court today. And I think Ms. Kyla Green said that he may be deceased as well. So the court has jurisdiction over this case in Medina County, and the court acknowledges or finds that it's not necessary to serve any other party at this time. I'll find that the department has proved that there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession. And in this case, there is no person entitled to possession. And for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal. And reasonable efforts have been made to enable the child to return home, but there's a substantial risk of a continuing danger if the child is returned home. Child is a legal term of art, so I don't want you to take offense that you're 14 years old and we're calling you a child. That's just how we refer to anyone under the age of 18 in our cases, okay? Court finds that Zane was at a mental health hospital and was ready for discharge on February 26, 2024. And that due to what has been represented to the court as ongoing mental health concerns, the folks that she was with, the Hendersons, were unable to pick her up. Court finds that services were offered to the Hendersons, but there were barriers with consent, legal consent, and transportation, and that further services that were offered to enable the Hendersons to become medical consenters were refused. And there is also a concern in that Mr. Henderson is a registered sex offender. The court finds it's in the best interest of Zane for the Department of Family Protective Services to be named as a temporary managing conservator. Court orders the department belong to study both Donna Carter and Aunt Sandra Reyes as possible placements as contacts for Zane. And the court orders the department belong to also look into contact with Jeffrey Henderson and Christina Henderson based on a therapist's recommendation. Court will order the department belong to immediately secure a therapist for Zane to begin working with Zane on whether or not contact with the Hendersons is appropriate. Everybody here has heard Zane say that she wants contact with the Hendersons. So I want to make it a paramount. Of paramount importance that we really look into that and see whether or not that would be appropriate. Obviously, we're in this situation due to some concerns, so those concerns need to be addressed and taken seriously before we move forward with any further contact. Now, Zane, what that means is I just need the information in front of me so that I understand what the professionals involved feel is in your best interest. That's how I make my decisions. I don't get to go to these places and talk to these people myself unless they come to court. And I don't get to see information on your case, including documentation and paperwork, unless it's presented to me in court. So that's as far as I can go today based on where we are in this case. But like I told you earlier, my intention is to try and meet your desires as much as we can and to protect you, okay? So those are that's why I'm making those orders. Court finds that the goal for Zane is long-term residential treatment. And I want to order the department belong to look at potential placements as well as figure in a school environment for her. Are you in the 8th grade, Zane? Okay. So we need to be looking at a placement that will allow her to do what she wanted to do, which is go to school and be like other people who are her age and have that sense of normalcy when it comes to her education. We will be back for a status hearing on May the 14th, 2024 at 3 p.m. That's May 14th, 2024 at 3 p.m. And Zane, what's going to happen at that status hearing is we're all going to come back and I'm going to hear whatever's happened in between today and May 14th to see how your progress is and to see how or what information has come to light based on the orders that I'm making today regarding these people that we're going to be looking at for contact with you, okay? Ms. Kyler Green, I'm obviously not going to give an admonishment to any parents. Is there anything else that I've failed to address today?
No, Your Honor, I think you stated that you agreed with the reasonable efforts of the department, but I don't know if you made it an official finding.
if I didn't make an official finding, I do find, I think I did when I read the statute, but I do find, based on what I've heard today of the circumstances, that reasonable efforts were met.
Thank you.
I really don't see, just speaking casually, any other alternative or solution at this point. And I definitely don't want Zane to be in a mental health facility any longer than he has to be. Miss Savage, anything you want to add?
No, Your Honor.
Okay. Well, thank you all for your time and your service. Like I said, Zane, if you have any questions or you want to meet with me privately, you just let Miss Savage know. If not, then I'll see you on May the 14th, okay? I know this is tough. I know it's confusing. And I'm sorry for that, but we're gonna move forward and we're gonna get you through this, okay? If you said something, I couldn't hear you. All right. Then thank you all for your time and your service. I'll see you May the 14th at 3 p.m. If nothing further, all parties are excused. So nothing but the truth, so I hope you got it.
Yes, I do.
Thank you. We're here today for the status hearing, and I know this is a unique case, but we've got some things to cover that we talked about when we were here last time. First of all, is there any Indian child heritage in this case?
No, there isn't.
All right. And I'll just jump right ahead. Did you all hold a family group conference?
Yes, we did.
Okay. And considering the circumstances, did you develop a permanency goal?
Yes, we did.
And what is that?
It's relative adoption and relative conservatorship.
With the Hendersons?
No, we are trying to locate other family members at this time.
Okay. So we rule the Hendersons out?
Yes.
Okay. And what else did you discuss at your family group conference?
Really wraparound supports that Zane is needing. He's had a lot of hospitalization since coming into care. So really trying to develop a plan moving forward of what supports we can get for him.
Okay. And where is he placed at this time?
He's at the Touchstone campus, but right now he is hospitalized at Clarity.
Touchstone is in Bexar County?
It's in Guadalupe County.
Guadalupe County, okay. Is that placement safe and appropriate, meeting his needs?
Yes, it is. There have been concerns though that he hasn't really acclimated to the program. This has been his fourth hospitalization since being placed there.
Are you looking at other placements?
Clarity has a partial hospitalization program at that campus, and so we are trying to figure out, once he gets discharged, if he can be admitted into that program, and then he could go to campus from 8 a.m. to 4 p.m. and then go home to Touchstone in the evenings.
Okay. So is it in his best interest to remain at Touchstone at this time?
Yes.
Is he up to date on all of his checkups?
Yes, he is.
Is he receiving any psychotropic medications?
Yes, he is.
Is the review up to date?
It is, and Clarity just changed his medication from what's listed on the report. He is now on Latuda, 40 milligrams.
How are his behaviors? I mean, what's the reason for the hospitalizations?
The first few hospitalizations were due to suicidal ideations, trying to run away from campus. More recently, his behaviors have gotten a little bit aggressive with staff. He's been punching walls, wanting to contact family members that are not on his call list right now. And whenever staff have put him in containments to make sure he's not hurting himself, he'll start biting and kicking them. This last hospitalization, he had also made some homicidal remarks about a younger student on campus, and a mental health officer had to be called out.
Okay. Do you believe that the care he's receiving in his hospitalizations is appropriate to address these concerns?
Yes, I do.
And I think the answer to this is clear, but you believe it's in the best interest of Zane to be in the temporary managing conservatorship of the department belong?
Yes, I do.
And is this the least restrictive placement available consistent with the circumstances?
Yes.
All right. And do you believe that family plan of service that was created for Zane is narrowly tailored?
Yes, there isn't a family plan of service. There wasn't any legal guardians to create one for.
But you said it contained wraparound services, right?
Yes.
Okay. So do you believe that those services are narrowly tailored?
Yes, I do.
Okay. And you believe they're in his best interest?
Yes.
Okay. Mr. McKeska, any questions?
No, Judge.
Ms. Savage,
No questions, Your Honor.
what do you have to report at this time?
Zane is definitely struggling. I believe this is hospitalization number 4 or 5. I know the medications have frequently changed because he's also going to different hospitals. So I'm hopeful that if we can get him into this partial hospitalization program, it will give him a consistent treatment plan where hopefully he can stabilize. He does like Touchstone. He is wanting to go back there, but ultimately he does want to be in a foster home. And so that's not even something we can look at right now when the reality is he's going to hospital every week or 2 weeks at this point. He does voice wanting to have still some sort of connections with family, but we have not been able to find appropriate family. So hopefully we can continue that search because I think that support, he's like really desiring connections and support like any child. And we just don't really have that for him right now. So I do recommend him going back to Touchstone at this time. I think at least he's here where we can keep an eye on him versus him going to RTC somewhere much further. But hopefully that hospitalization plan or program would be in his best interest for sure.
Okay.
And we do have a meeting for Monday with you, Your Honor, but I think that's going to be contingent on if he's out of the hospital or if he's not started that program. So I believe that's at 10. So I will touch base with placement to see if we're still going to be able to facilitate that. Probably Friday to see where he's at.
Okay. Well, just let me know. That's fine. All right. Any other requests or orders?
No, Judge.
Okay. Then for the purposes of the status hearing, court finds there's no Indian child heritage in this suit. Court finds that the permanency goals relative adoption or relative conservatorship. Court finds that as of today, no other appropriate family members have come forward. Parties were able to hold a family group conference to create a service plan for Zane. The services in that plan are narrowly tailored in Zane's best interest and will be orders of the court. Court finds that he is up to date on his checkups, that his psychotropic review is up to date, and that his placement is safe and appropriate, meeting his needs. As far as best interest goes, it sounds to me like we don't really have any other options at this time. This is the least restrictive placement available, but it would be in his best interest to continue to explore other placements until something more appropriate comes available. It's good to know that Clarity has that part-time program, so hopefully we can utilize that. Court finds that the care he's receiving is appropriate to address the concerns with his behavior, and that it is in the best interest of Zane to remain in the temporary managed conservatorship of the department / belong. Anything I failed to address, Mr. McKeska?
No, Judge.
All right, we'll be back for this initial permanency hearing August 13th, 2024 at 2. August 13th, 2024 at 2. All right, well, Ms. Savage, just let me know when you find something out. I mean, even if it's Monday before the meeting, I'll be here. So if we need to move it back, we can move it back, but hopefully we can have that. All right, thank you all for your time and your service. If nothing further, all parties are excused. That concludes the docket for today.
Thank you, Judge.
We have all the attorneys here, but we only have service on Mr. Silvas, who I can see is here with us. I'm not sure we can proceed. What's the department's position before I call the case?
Judge, we don't have contact with the mother, and she hasn't been served, so I would announce not ready based on that fact today, and ask the court to reset this matter and allow us to continue our efforts to make service or perfect service. If we're not able to perfect service before the next hearing date, then I'll probably be requesting the court to hear the case under chapter 262.201 subsection O. But I want to make sure that we have those diligent efforts made prior to making that request.
Understood. All right. I've got a gentleman here in an orange shirt. Sir, could you please remove your hat? No, he's got no volume, no audio. All right. I'm not sure anybody can even object to that, but I'll give all the other attorneys the opportunity to weigh in if anybody has some alternative information.
Judge, if I may, on behalf of the child.
You may.
Thank you. I may have some information on her whereabouts that I can convey to the department. In addition, placement is in need of daycare. So I would request, if possible, that the court make an order that daycare be provided for this child.
Your Honor, and Mr. Silvas was served and he is present, and I have filed a motion for DNA testing, and we know how long that takes. So I would ask that the court order that today so we can at least start the process.
Mr. McCaskill, any response to Ms. Swallow's request for daycare under temporary orders?
Judge, I would have to talk with the department. I don't have any specific objection. I just need to make sure that they qualify for it under the requirements of our various policies. And as far as the DNA testing is concerned, I have no objection to that.
Okay. Yeah, I'll grant the DNA testing. That's not an issue for me. Sir, with the orange shirt on, would you please remove your hat for me? Thank you, sir. Mr. Rudkin, anything from you?
I've had contact with my client, Albert Machaca, gave him the Zoom information for today. I don't know if he's logged on or not, but he'll be contesting paternity. And although I've not filed a motion for DNA testing yet, I will be doing that either today or Monday morning.
Well, do you want to just file an oral motion right now?
Sure. We'll make that request for a paternity test consistent with the one that's was filed by Ms. Pearsall.
That's granted.
Okay.
So we'll test Mr. Menchaca and Mr. Silvas. As Ms. Pearsall pointed out, it may take a little while, so we can at least get the ball rolling on that under the emergency order. Mr. McCaskill, do you want to confer with your client now regarding daycare, or do you need more time?
No, if I could just be put in a breakout room with them, Judge, just to make sure. Like I said, if placement is employed for the minimum amount of time, it's not an issue. Thank you, Judge.
You're welcome. All right, Mr. McCaskill, what have your clients presented to you?
Yeah, Judge, after being able to confer with Ms. Mitchell, there's no objection for Ms. Swallow's request.
Okay. Ms. Peterman, I know you probably talked to Mr. McCaskill, but there's no immediate safety concerns with the court's plan to reset on your end, is there? I didn't hear you, but I'm pretty sure I read your lips right to say no. Okay. All right, then. Court will, I'm not going to call the case unless anybody needs me to. I think I can make these orders without doing anything else. So we're going to reset the case to April the 3rd at 2:30. April 3rd, 2024 at 2:30. Court will extend the emergency temporary orders at this time. I'm going to order that daycare under the emergency orders be provided for the child, daycare assistance. And I have granted Mr. Rudkin's request and Ms. Pearsall's request for DNA testing on their clients. I'm not going to make any other orders today. As far as the child, everything that's in place right now will remain the same. And I'll see you all back April 3rd at 2:30. That's a full docket, so there's a lot going on that day, so please be on time. Anything else I need to address?
No, Judge.
Okay, thank you all for your time and your service. You're welcome. Have a good afternoon.